petition out of principle that acknowledges the facts and that he regrets these facts, globally speaking. And I think that if this element is extremely important, in detail, the document that relates very exactly each one of the points, I think it would be only necessary to include this document in the case file so that we can go directly into the examination phase, that is to say, in the substance of these proceedings.
Mr. President, the lawyer for Group 4, the lawyer for the Civil Party Group 4, please. The floor is yours. Oh, you already spoken. It's okay then. Please, the counsel for the defense.
Your Honor, I am aware of what Maître Martin Jacquin is presenting to us. Maybe is to make things more clear. Maybe we could do this in two different ways. That is to say that the prosecutor would read the paragraphs that he proposed to us, and at the end of each paragraph, the defense will rise to say, we agree, or to specify the comments that the accused wanted to provide. And it will be then more dynamic, let's say. I would say it would be a more dynamic presentation. We could say, and indeed, this would address the concerns that were presented by Maître Jacquin, and which I perfectly understand. This is my proposal, if, of course, my colleagues from the prosecution side agree.
I think sometimes the more we speak, the more complicated things get. As I said earlier, most of the facts are agreed to and will hopefully help this chamber. Some of them, and some of the key ones, are not agreed to by us or by the defense. And the accused himself, as far as I understand the procedure that was taken, has himself commented on some of those specific facts. Now, obviously, the defense can file any documents it wish with whatever comments, and it will be debated if there is to be a debate. However, I fear that if we were to read into the record today or at any other time written comments by the accused, we will get that debate. In other words, I fear that if the accused, through this means, would be to, in essence, testify about some of the facts, it will lead to, perhaps, debates, which we will have at the relevant times in those proceedings when the accused makes his position known on some of those specific facts. I would suggest, although, as I'm sure well-intentioned the request or the suggestion is from my learned friend, that perhaps, if only for the sake of serenity, at this stage, we do read into the record what is agreed without comments. We could indeed read the proposal either singly or by subject or in bunch, after which the defense would make his position, their position known. I suggest that then the record would be quite clear about what is agreed to, and the rest will be left for its proper time and proper form during the substantive part of this trial, or the next substantive part of this trial. I suggest personally that this is probably the best way to achieve what I think is now developing as a consensus on this issue. Thank you.
The President, please, the Defense Counsel.
I agree so that we only present the paragraphs on which the accused has said that he agrees or that he does not contest. I agree with that, yes. But we will therefore not read the paragraphs on which the accused interpreter has provided comments. We will just focus on the paragraphs on which the accused said that he agrees or which he says that he does not contest.
The President, now the bench has to retire to deliberate, and it is also a break time, so the chamber will take a break for half an hour for our deliberation.
Kaing Guek Eav.
Graffier, please be seated. The President, the trial chamber will now resume. First, the chamber would make an announcement to the co-prosecutors and the defense counsels and all the involved parties. The trial chamber decides the co-prosecutors and the defense counsels to read the agreement on the facts and the facts that are not disputed. And for some other issues, we will address them later. However, for the reading of the agreement on the facts, it will be done in this afternoon. So, please, the co-prosecutors and the defense counsels are prepared for the reading this afternoon. For our next proceeding, the chamber would like to ask the defense counsel, Mr. Kasavut, that yesterday you made a statement in response to the charges made by the co-prosecutors regarding the legality of the charges against your client. It is unclear whether what you raised is a request to the chamber to resolve that particular issue before the proceedings, or it is just to bring to our attention during this part of the proceedings as a response to the co-prosecutors. If it is a clear request to the chamber, we would like the councils to point to the facts or to relevant issues regarding to your request. So the floor is yours, Mr. Kasavut.
Mr. Kasavut, I'm grateful to your honors. What I have already stated in my statement yesterday, I began with that I as a lawyer would like to give some observations to the whole court to consider my following comments. I think those arguments are just the comments for the consideration of the court. Number two, when the co-prosecutors asked whether I challenge the jurisdiction, I am not intending to challenge it because I am quite aware already, and I could have raised it in the initial hearing already if I wished to do so. So what I raised was not to challenge the jurisdiction. I only wanted the court to follow the Rule 98, Rule 7 regarding the jurisdiction of the court over my client, because if he is not the most senior person or most responsible person to be prosecuted, then he should not be prosecuted. I just want to confirm that position, and I think they are just my comments for the court consideration. For example, I said that the co-prosecutors said that my client has something to do with the crimes against humanity because there had been some kind of armed conflicts and fightings between the Vietnam. And I would like to ask why my client was charged of crimes against humanity while Vietnam is not charged so on behalf of my client, I only ask for justice for my client. It's not to challenge the jurisdiction of the court. And regarding other points I raised, I asked that Cambodian sovereignty was not well respected, and I quoted Article 31 of the Cambodian Constitution that every citizen, every Cambodian citizen is equal before the law. And I ask, how can you say it is equal now, because many people are not charged while my client is charged. So I'm afraid that this is a violation to the Cambodian Constitution. And the reason I explained to the court, and I at this time would also make a request to the co-prosecutor to list down all the names, those people who are most responsible and senior people for democratic Cambodia. How many are they, and bring them all to be prosecuted, and or otherwise the court shall issue a decision or judgment to extinguish criminal actions. So I want the court to also consider this, to issue such a judgment to make sure that justice is done for all the dead people and people who survive. But finally, I do not intend to challenge the jurisdiction.
The President, for our next proceeding, the defense counsels and the accused raised an attempt to issue related to the provisional detention of their client. The trial chamber would like to ask the defense counsel, at this stage, if you insist on raising such issue, and if so, what is your request to the trial chamber regarding this particular issue?
Thank you, Your Honor. The defense had indeed informed the chamber as of the preliminary hearing that it would bring up the question of detention. Can I call it provisional detention still, however? A detention that has been going on for 10 years is no longer provisional detention. And that is the question that I wish indeed to expand on before you, if you give me the permission, Your Honor. As we have reminded,
the President, please, the lawyer. The President, the floor is yours for the Council.
Merci, Monsieur le Président.
Your Honor. As we have reminded initially, our client was arrested on the 10th of May 1999, and he was then arrested by the authorities of the Kingdom of Cambodia, and he was transferred before the military tribunal. And he remained before this tribunal during all of these years, up until the 30th of July 2007, when the co-investigating judges of the ECCC presented an arrest warrant against Mr. Kaing Guek Eav, aka Duch, and he was that very same day transferred from the detention center of the military tribunal to the prison here at the ECCC. And we have immediately requested that he be released, and given the amount of time that he had spent since his arrest. And we reminded that according to Cambodian law, but also according to international law, it was not possible to maintain someone in detention for such a long time. The investigating judges presented an order, and if I can sum it up, or summarize it, they stated that there is a problem, but it is not our problem, however. It is the problem of the Cambodian authorities. And we then appealed before the pretrial chamber. And in their review, the co-prosecutors, if I can summarize things again, stated that there is indeed a problem, but it is not our problem. And the pretrial chamber presented a decision in which they stated, and I will summarize it, we have no problems, and you will submit this question to the trial chamber. And we are before the trial chamber now. So, we, of course, are aware of the difficulty, including in relation to the civil parties. How can we imagine when the accused acknowledges, when he expresses his remorse, when he asks for forgiveness, how can we imagine that at the same time he can ask for his release? Well, simply because we have the most heartfelt respect for this chamber and for the ECCC, are therefore requesting here to state law, nothing else, just to state law. Even if it is a decision that is hard, that would be difficult to understand by the public opinion and by the victims as well, is the first decision that your chamber should render. Isn't it precisely a decision that should recall law? What does the law state? First of all, the Cambodian law, we have we have recalled the Constitution of the Kingdom of Cambodia from the Constitution of 1993 and the Criminal Code of the Duch from 1992 and the law concerning the duration of provisional detention from the 26th of August 1989. And in virtue of all of these, by virtue of all of these texts, it was provided, and in particular by virtue of the law of August 1999 and of its first article, it was provided that provisional detention of individuals accused of genocide, war crimes, or crimes against humanity would not exceed 3 years. That is to say that as of February 2002, Duch should have been released. Or, to say things in other terms, since February 2002, there is no legal foundation. I repeat, there is no legal basis for his provisional detention. So there was, however, renewals that were presented by the military tribunal in a rather incomprehensible way. And I remember of the very heated debate before the pretrial chamber, the debate between Madame Shileng and my friend Maître Karsavut, Council Karsavut, Madame Shileng explained that we have to maintain Duch keep him free for reasons of for public reasons, because we are afraid we fear for his safety, we fear for the safety of the victims, so we should maintain him in the detention. And Maître Karsavut answered, well, Your Honor, I agree with you. You are entitled to be afraid. For 1 year, yes. For 1 year, yes. But you are entitled to be afraid for 2 years. Do you remember? You are entitled to be afraid for the 3rd year as well. But after 3 years and 1 day, you no longer have the possibility of being afraid, because the Cambodian constitution stated that after 3 years and 1 day, you must release him.